Major breaking news out of the United States Court of Appeals for the Ninth Circuit. A big win for gun owners and hunters based upon a lawsuit that was dismissed involving a law known as the Resource Conservation and Recovery Act, or RCRA. Let me tell you why this is a big win for the Second Amendment, even though it doesn't directly impact, or doesn't specifically talk about, I should say, the Second Amendment's right to keep and bear arms. Stay tuned. Hey folks, I'm Mark Smith, host of the 4 Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the book, First They Came for the Gun Owners, that lays out the details by the anti-gunners as to how they're going to try to take away our gun rights A to Z, including red flag laws, political violence, and so on and so on. Check it out on Amazon. First They Came for the Gun Owners. All right, major victory out of the Ninth Circuit Court of Appeals based in California. This involves a federal statute called the Resource Conservation and Recovery Act, usually referred to as RCRA. Now, in this case, there was a lawsuit brought by the Center for Biological Diversity, alleging that the United States Forest Service was a liable party under RCRA for allowing hunting to take place in the Kaibab National Forest. Now, the reason why this is important is that the Kaibab National Forest is a very popular place for hunters. And it's legally owned by the United States government. So the nonprofit Center for Biological Diversity group and others brought a lawsuit, literally like 10 years ago, claiming that because the United States Forest Service allowed for hunting with lead-based ammunition, this violated RCRA and gave jurisdiction to federal district court judges to enjoin or require the United States Forest Service to basically ban hunting with lead ammunition on this federal property against the Kaibab National Forest. Now, this is a big win because what just happened was a 3-judge panel in the Ninth Circuit Court of Appeals, in a powerful decision, which I'll link to down below, said that no, the lawsuit brought by the Center for Biological Diversity against the U.S. Forest Service, with interveners on behalf of the U.S. Forest Service, by the way, the National Rifle Association, the National Shooting Sports Foundation, and the Safari Club International, they all supported the U.S. Forest Service, which said that we're not responsible and we're perfectly fine allowing hunting to take place in the Kaibab National Forest. But this Center for Biological Diversity wanted to force the United States government to prevent lead ammunition from being used in this national forest, this national park, if you will. The good news is the 3-judge panel, in a unanimous decision out of the Ninth Circuit, said that the lawsuit failed. It failed to state a claim. Now, this is quite interesting. I think it speaks to a lot of issues involving guns. Specifically, the court said that if you read the RCRA statute, it says that if an owner of property or some other person involved with property contributes to a toxin or toxicity or pollution on, for example, federal property in this context, then they can be held liable and enjoined from doing what they were doing in the past going forward. So the argument by the plaintiffs in this case was that under the RCRA or statute, the federal statute, Resource Conservation and Recovery Act, the U.S. Forest Service had an obligation to prevent hunting with lead ammunition. And by failing to regulate the hunting with the use of lead ammunition on this federal property, the Forest Service contributed under the relevant law to the poisoning, the creation of toxins, i.e. lead rounds or lead ammunition, in this federal park, which is owned by the United States government. As a result, the United States Forest Service contributed, as that term is defined by the statute, to the polluting of the Kaibab National Forest. Now, of course, what's really going on here, as I see it, was really an attempt to prevent hunting from occurring in this massive federal lands, or on these massive amounts of federal lands. The argument went that because lead ammunition could be ingested by certain animals that maybe were feeding off the carcasses of animals that were shot but not recovered, or were field dressed, whatever. There was a danger that certain animals in the Kaibab National Forest could ingest this lead associated with the lead ammunition, and that would be terminal to them. And as a consequence, this violated RCRA, and the United States Forest Service, as the manager of the government's property, had a duty to step in and prevent the use of ammunition with lead in it by hunters and others. Well, the federal court said, no, this is not true. They dismissed the lawsuit. And the Ninth Circuit, I'm happy to report, says, nope, no can do. We're going to rule for the U.S. Forest Service, the National Rifle Association, the Safari Club International, and the National Shooting Sports Foundation, because we, the three-judge panel on the Ninth Circuit, do not believe that the U.S. Forest Service's decision not to regulate, not to ban the use of lead ammunition in the Kaibab National Forest. And by the way, the Kaibab National Forest, if you're not sure where it is, it's right beside, I believe, the Grand Canyon, like right out there, out west there. So I bring this up because the court said that refusing to regulate does not constitute contribution, and as a result, the federal district court does not have jurisdiction to enjoin the U.S. Forest Service in any respect, including by requiring them to ban hunting or ban the use of ammunition with the lead associated with it. So again, this is a big victory because this is obviously an attempt, as I see it, by the plaintiffs to try to make it harder for people to use firearms. As you know, under the Heller decision, even though the RCRA case involving this Ninth Circuit we just talked about, this does not specifically deal with the Second Amendment. It sort of does, right? Because under the right to keep and bear arms, you have the right to keep, which means to possess, and the right to bear, which means to use guns. And the U.S. Supreme Court in the Heller case says we have a right to use firearms for all lawful purposes. I know we spent a lot of time talking about the importance of guns for self-defense against all forms of tyranny, whether that tyranny might be a rogue government, whether it might be a foreign invasion, whether it might be a criminal on the street, whether it might be an animal trying to attack you, whatever that form of tyranny is. We usually talk about the Second Amendment in the context of self-defense, but that is not the only reason to possess and to have firearms, because the Supreme Court has made references to any and all lawful purposes, which obviously includes hunting. So if you prevent people, for example, of being able to hunt or otherwise use their firearms in the Kaibab National Forest, specifically with the use of lead ammunition, well, guess what? You are infringing, arguably, on the right to keep and bear arms. Nevertheless, this court, by virtue of dismissing this case, saying that a claim under the Resource Conservation and Recovery Act cannot stand, is effectively a win for the Second Amendment, even though this case doesn't talk about the Second Amendment itself. So there's only two final points I want to make about this big win in the Ninth Circuit. The first is, just as a reminder, that the Resource Conservation and Recovery Act, just so you want to, if you don't want to know exactly what it says, I'll put a link to it down below, but basically it's defined as a comprehensive environmental statute that governs the treatment, storage, and disposal of solid and hazardous waste. So that's what RCRA means. But the other thing I want to point out is quite interesting. It's a little bit of a nuanced legal point, but I think it's important. As you know, when the gun industry, gun companies get sued because someone engages in a mass shooting, an individual engages in a mass criminal act over whom, of course, the gun companies have no control. I think this decision by the Ninth Circuit actually speaks to that, because if you think about it, what they're really arguing here, what the plaintiffs were arguing here in this case, and by the way, the name of the case is the Center for Biological Diversity versus the United States Forest Service. So if you think about what they're arguing, they're saying that the U.S. Forest Service has a duty to prevent the use of lead ammunition by hunters and others in the Kaibab National Forest, okay? And because third parties over whom they have no control, meaning hunters, are the ones that are actually shooting the firearms with the lead ammunition, allegedly, it is appropriate, according to the lawsuit that has now been dismissed, of course, that the U.S. Forest Service should be held liable for the acts of these hunters and these people with guns. But the court rejected this, and I think this is very good for several reasons. The most important, if you think about it, is they're literally saying that, and here's what the court says, because the Center for Biological Diversity admits that the United States Forest Service is not the source of any lead ammunition found in the Kaibab National Forest, the question is whether a person who has some power to prevent someone else from contributing to the handling, storage, treatment, transportation, or disposal of hazardous waste is liable under RCRA. And here the court says no. Just because the U.S. Forest Service could have regulated but chose not to does not mean they contributed to any alleged lead or any alleged toxins in the forest or in the park, because that was caused by third parties over whom the U.S. Forest Service had no control, i.e. the hunters or the people using the firearms. So again, I think that kind of speaks to, again, these lawsuits that should be banned under federal law anyway, among other things, that when they sue these gun companies for the acts of third-party criminals for using firearms in a way that's clearly criminal, over whom, of course, the gun companies have no control, it seems to me in many respects this decision by the Ninth Circuit speaks to that and says, we're not going to hold the United States Forest Service responsible for alleged acts of pollution by hunters or third parties over whom they have no control. So I think that's actually kind of a powerful precedent in support of the gun companies and gun industry, if you think about it in a nuanced way. Nevertheless, a big win for hunters and other gun owners, another setback to the anti-gun movement as I see it. Anytime we can thwart people that are seeking more regulation over any lawful activity associated with firearms, that is a good thing, and certainly that is the case here as I see it. Again, I'll put a link to the decision down below. You can check it out for yourself. And again, thank you for watching here at the Four Boxes Diner. If you haven't subscribed or liked this channel, please do so. And don't forget, by the way, some people say that they've been unsubscribed. So if you're not sure if you're subscribed, it's always good to resubscribe just to be safe. And again, feel free to follow me on Twitter at Four Boxes Diner, where I put out additional Second Amendment content every day. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.